Welcome to this today's discussion. We are going to talk about the recent lawsuit that we filed last week on behalf of the legislators, and we're going to talk about the upcoming cases. And we're talking about some of that. No, nobody can hear me. Why can't they hear me?
Or actually, I'm so sorry. We can't notice.
Apparently, you can hear me. So it's always a cluster when people say this is easy. It's not. Anyway, then we're going to talk about upcoming cases that we're going to be putting together in the next couple weeks. So let's start with the cases that let's see right here. I want to talk real quick about your risk. Here we go. Your risk to get COVID. Make this bigger so you can see it. As our president said not too long ago, average age is like 78. People do die who are younger, but I'll just give you this while people are chiming in or getting on board. The chances of you dying from this is very small. People our age are dying, but it's small. And you have to weigh these things in accordance with the same way you weigh everything else. And so I'm a motorcycle rider, so I'm a higher risk taker than most people are, at least I used to be. You make these decisions, but the idea that this is risk-free, or anything we do is risk-free, is strange. The H1N1 virus of a couple of years ago was pretty deadly, and this is probably 2 or 3 times that deadly. We didn't shut anything down. We did have to learn how to fight this thing, and so we should certainly take things seriously. People get upset about the masks. Let people work. I care about that. If you want to think that the mask is all that, or don't think the mask is all that, then that's fine. I don't want to fight about that. I do want to fight about over-the-top approaches to doing things. This is the website from the CDC, right? Everybody can see this. This is the actual CDC, their website, and they define what the coronavirus case is. And this is the current standard definition. When people talk about there are lots and lots of cases are exploding, clinical criteria, again, I'll make this bigger too so everybody can see it. If you have any two of the following, fever, chills, a headache, and a sore throat, at least 2 of those, then you could be considered by a doctor and reported as a COVID-19 case. Any one of these, you got a cough, you see a doctor and they don't have any other reason to think that you have a cough, guess what? You are a COVID-19 case. Of course, it's any 2 of these or any one of these. If you have a cough, shortness of breath, or difficulty breathing, and the doctor looks at you and says, well, I don't know why else you would do this. Poof, congratulations, you're a COVID-19 case. Now, is every doctor doing this? No, I know several doctors that don't. But the fact is that we've got exploding cases, and this is the actual CDC definition. So I don't give a rat's rear about the exploding cases. We're testing everybody. Lots of people have problems. I myself got the COVID-19 test a couple weeks ago because I had a fever for a while and I was freaking out. And no fever. Was I reported as a COVID case? I don't know. But there you go. So be aware of that. This is a real thing. You can go look at CDC, probably case definition 2019, 2020, and you'll see the same thing. So that's real. What I hope you saw this week was, this is our website. In case you want to go find this, you can go to our website, norridlaw.com, and you hit blog. And blog 2020, 2019. So 2020, I've only had 2 blog posts. I talk one about Shelley and one about the contact tracing suit. And if you want to get the entire suit, it's down here. Click here to download the petition. So this is the petition. There are 2 reasons that we should invalidate the contract tracing contract between MTX and the state of Texas. 2 basic reasons. Now, lots of sub-reasons, but they're 2 basic reasons. The first one is there are no competitive bidding rules in awarding the contract. As you may know, when the state or most cities go off and they're going to invest hundreds of, actually more than $50,000 in most cases, they have to have competitive bidding. Competitive bidding means that you post the specification for the contract out so everybody can see it. You invite people to make suggestions and people will have a phone number to call and say, what if we want to do it this way instead of that way? And so there's a lot of back and forth. For a major $300 million contract, this usually takes some time, and you have a number of people to come in, and somebody says, well, we can do this without hiring 5,000 people. They'll look at that. And so there was a whole lot of that did not happen. It did not happen. Now they'll say, the governor would say, well, it's an emergency, it's a disaster. I don't have to put up with any of that. I can just do what I want. The courts will decide that. We don't think that was correct, but that's one of the two prongs by which we are attacking this contract. The other one is that we have this Texas Constitution, and it has a separation of powers. Separation of powers says that legislature makes laws, executive implements those laws and takes care of those, enforces those laws. You don't have an interim situation where we got this big issue, and so the governor says, I'm going to do what I want, and I'm going to set up $300 million policies, become a state policy, and implement this and send out contracts and do all that. That's a major state policy. The Texas legislature is supposed to do that. Now, I'll mention the heroes of the moment. The heroes of the moment are these 5 fine individuals: Mike Lang, Kyle Biederman, William Zedler, Bill Zedler, Steve Toth, and Bob Hall. Bob Hall is state senator. The other 4 are all state reps. You may be asking yourself why your state representative was not part of this. If he calls me, I'm happy to add him. But he's probably not going to, because he's probably concerned about repercussions, because the governor is going to be mad at him and not invite him to some party somewhere or make sure that something doesn't happen. This is a problem. This is a problem. The state legislature makes laws. And so these are legislators, and they should be discussing this issue. And they didn't. Now, one of the fun things that we talk about sometimes is things the Supreme Court has said. The Constitution is not suspended when the government declares a state of disaster. It's not suspended. You still have stuff you've got to do. And so, and we're just going to go through this a little bit. We are suing the Texas Department of State Health Services. Phil Wilson. Can Phil Wilson really sign a contract as an acting executive commissioner who has not taken an oath? It's not discussed in here. We might discuss that at a future point. Of course, we are suing our good friend Greg Abbott because he's the one that's causing the problem, and of course the state of Texas, for which he leads. And then because MTX Group, we want to declare this contract no good, so we're going after MTX. MTX was a small company not too long ago, still is, not too big. They never did anything like this. If you search for some criticisms, Senator Hall had a number of statements about this as it was going on. I would encourage you to do that. We filed this down in Travis County because Travis County is where the Department of State Health Services is. And so that's required. So this started, of course, on March 13th. You had Governor Abbott say, we've got a state of disaster. Now let's talk about that for a minute. Nobody understood or believed, nobody really knew how big of a deal this thing was on March 13th. We didn't know if it was zombie apocalypse. We don't know if this umbrella corporation is going to be doing this on purpose. We didn't know what is going on. And so we would not file a lawsuit like this on March 15th or March 20th. But as I'm fond of pointing out, I got the opportunity to watch Casablanca not too long ago, and I'll say that when they closed down Rick's, which is, of course, Humphrey Bogart's place, Humphrey Bogart and Rick is asking his accountant, how long can I last? And he says, a couple of weeks. That's very normal. The reason that story rings true is because that's what most people can do, a couple of weeks. But at some point, you have to live. You have to have your life. And so what the governor did, though, is he just said, we're going to just do this essential, non-essential thing. And so we're going to do it this way, and we're going to say that I, as the governor, get to do all these things. And so 418.016, this is part of the state government code. The governor can suspend laws that prevent, hinder, delay necessary action. As far as it can be suspended upon written approval of the office of the governor. So he can do this, saying, I hereby suspend such statutes and rules for the duration. Can you do that? That's interesting. Here, let's go over here, and I got two of those up. Let's do this. Texas Constitution, and we're going to Bill of Rights, Legislative Department. Let's go there. Nope, that's not it. I want to do this. I like to do it real time because you can see that you can do this. This is Article 1, suspend. Who can suspend laws? Let's look at that real big so everybody can see it. Who can suspend laws in this country or in this state? Same thing. Suspension of laws, Article 1, Section 28. No power of suspending laws in the state shall be exercised except by the governor? No, the legislature. The legislature gets to suspend laws. Now, some people will say, but Warren, didn't the legislature give permission to the governor to suspend laws? They tried to. That is what's attempted. And so we're going to look at that in a minute. But we're going to find out that a state legislature cannot unduly do this kind of thing. So this has gone on for some time, nearly, let's see. And one of the problems is that because the governor is not a legislature using a legislative process, what he's done is often been unbalanced and been quite often irrational. For example, liquor stores haven't closed ever. They've never closed. And people say, well, why should liquor stores be open when vape shops had to close and daycares can stay open? Every grocery store can be open. As I pointed out in other places, Condom Sense, it's never closed because they call themselves medical devices, because I guess grocery stores don't sell those things. Anyway, it's somewhat irrational. Look at state certified hairstylists, 1,500 hours of training had to close. That, of course, that was the Shelley Luther case. She actually has training. You know, all of her people had training in doing things in a way that was sterile and keeping track of hygiene. Liquor stores don't have that, but they get to stay open. And so anyway, the governor finally realized he didn't want people in jail just for going to earn a living, so he finally issues effectively a one-page executive order taking back the idea that people are going to go to jail for trying to earn a living. Interestingly enough, and this is a true story here, right now in Dallas, as long as you steal less than $750 an hour a day, less than $750, they won't put you in jail. They just won't do it. But if you work in a way they don't approve, they will put you in jail. That was Shelley. So if Shelley had gone next door and stolen up to $750 worth of stuff from the store next door, no problem. But being in her own salon and having somebody earn $1 was, well, that was jail worthy. Anyway, so we have this MTX contract. On April 27th, he's going to put together a contact tracing. Some people do know, we all kind of assume that people know what they mean by that. Contact tracing is this. Somebody goes to the doctor, it looks like you've got the COVID. And so we're going to track everybody you've talked to, everybody you went to, restaurant you went to. You notice you go to these restaurants now and they have the menus on the square. And you read the square and you read it online. Guess what? You're being tracked. So, or many of you will be. I don't know if everybody does it that way, but it's a tracking means. Well, we can find out everybody who went to that restaurant that night. And we can figure out everybody you touched. Is this a bad thing? That's not what this is about. I don't know if this is a bad thing or a good thing. I'm not saying it's a good thing or a bad thing, although I think it's a bad thing. Even if I think it's a bad thing, that's not why I would file suit. I don't file suit on everything I think it's a bad thing. I'd be awfully busy. So, but the question is it done right? Even if we think something needs to be done, we still have to follow rules. And so, in this case, you can kind of summarize it, the contact tracing program. And this is 183 pages, right? So I have the entire contract in this document. You can read the whole contract. You can read the spec. and you can see what's there. So it's to identify individuals who contracted COVID-19 who may need to be quarantined or tested, whatever that means. And so it's been, of course, roundly criticized. So the Department of Health Services, DHS, sent out an RFP, request for proposal, on May 5th. And they put together a vendor, and they wanted thousands, up to 5,000 agents. There are ways of doing this without 5,000 agents, and typically in most situations, in a situation like this, the vendors would contact them and say, well, I've got an alternative proposal. It wouldn't use all these people, and you would consider that. But if you're just trying to adopt a system that winds up being a job site, or to have 5,000 people that owe you their jobs, that's been done before in this country and most other countries. As we say here, the RFP was less detailed, and the RFP said you had to have 5,000 paid investigators talking about all these people's health. We had 10 companies into the process. All these, MTX eventually gets it. Little companies like AT&T, IBM, little guys. All these people, so 8 days, so they posted, they didn't actually post it, we found out. They issued this to a few number of people on May 5th, and then on May 13th, 8 days after it was sent to the select group, they awarded $295 million to MTX, basically nobody's. Little to no prior history work the state. I'm not going to say there's corruption here. I don't know. Sometimes, as a friend of mine once said, control is its own reward. Would the governor prefer to give this contract to somebody who's going to hire 5,000 people inside the state and have all of them owe their job to him in an area, or give it to somebody who maybe just is going to resolve it all with a good app and a few dozen people somewhere? Who knows? But we do know is that it went to this small company. Now, where's the problem? Contract includes a legal authority section, and this is pretty normal. Let's see if I can do this. It's page 8. Let's see if I can go all the way down to this legal authority. Let's see if I can get down there. There it is, legal authority. So this is the actual signature document, and it says this contract is authorized by these 3 chapters of the Texas Health and Safety Code, and then of course 418 of the Texas Government Code that says the governor can do pretty much whatever he wants during a disaster. What's funny is that I think it's 1002, that section was repealed like 5 years ago. So I don't, and this kind of thing happens. You get people that they'll do a contract and they do cut and paste, and nobody ever noticed, oh, chapter 1002 has been gone now for 5 years. It's okay, but that's the kind of thing that happens if you're moving too fast. So let's go back. Back to legal authority. So we got legal authority, and that's what we're saying that. When we're up. So these sections of legal authority say that you can do whatever you want. How are we doing for time? I don't waste too much time. Okay, so the Texas legislature, and I wrote this, and people have said, no, the Texas legislature has approved this kind of thing before. And the governor doesn't need anybody's say so to do this, except that the contract itself says that the contract is subject to termination without penalty, because the authority and appropriations are subject to the Texas legislature. So even though they're saying no, we've got authority to do it, they're admitting in their contract that they don't. Anyway, so then they're also going to say that Section 81 of the Texas Health and Safety Code allows contact tracing. It allows, if you've got an emergency, the authorities can get driver's license records for purposes of notification. The contact tracing far exceeds driver's license records, so that's not going to get it either. Then we talk about probable cause and what a case is, and then of course Chapter 102, Act 1002 has been repealed for some time, 5 years ago, I guess. So one of the fun things we did on here is we got the declaration of Nick Richards. Nick was a employee of one of the bidders, and let's see if I can find that super fast. Maybe. This is, it's the very last thing. We'll just do that all the way down. So this is Nick Richards' unsworn declaration. And he was a consultant with Aspen Technology, one of the players. He's been involved in many of these contract tracing proposal processes. And he points out the RFP was far less detailed than other specs. They had no opportunity to ask questions or suggest alternatives. And then we just talked about that. And then we talked about what's going on here and what the spec required. One of the things he pointed out was that nothing here, by the way, HIPAA is HIPAA. I see people every day, it's HI, that do it wrong. It's HIPAA, no 2 A's, only 1 P. Are these people have to know how to handle HIPAA information? Are they required to do that? There's some certifications for that. None of that's really discussed in the spec and the way it needs to. Of course, people posted this RFP, and they only had about 2 days to really do it. They had 3 options ranging from 250 to 800 million, depending on how they're going to do it. And so it's just Nick pointing out that this was done fast and loose. So what we're doing is we're saying that there are at least 4 problems with this. The first problem is that you have to have authorization. A contract has to be provided by specific allocations of power. And we've got lots of opportunities, lots of case law on this. A public officer, like our acting Phil Wilson, may only make such contracts as they are authorized to make. You have to be authorized for this. And then you have to, and you can't say there's a disaster. Therefore, I can do what I want. There's some case law, City of Austin versus Now, and again, you can go look this up. If you say that you're going to claim a legal use, but it's really not, we can all understand this is an important issue. It's another thing to say that you get to go around getting $300 million contracts and establishing policies for the state. And so even if you say it's for a legal cause, if you don't really have a legal cause, then you don't have the authority. So we're seeking to enjoin the MTX's contract and its execution. I think I missed one, claim 2 and 1. We've argued that, there we go, that the MTX contract is void for lack of authority. You have to say that there is a specific appropriation. Now this is National Biscuit versus State. In this case, it was a specific payment of a judgment. Another friend of mine has pointed out that, well, that may not be applicable to this case. All of this is arguable, or at least most of it is. Some of it's not. Now, you can't have a contract last longer than 2 years, although this one is longer than 2 years, so it should be void just for that. The assertion by the state and by the governor is going to be that I have an appropriation for all of the Department of Health services, and I can switch money around anywhere I want. That's what they're going to say. And we're going to say, no, you really can't do that. You have to at least, if you're going to do something that's significantly different, then you're going to have to talk about it. And we're going to have to, and you're going to have to say that the contact tracing itself is something that you're allowed to do. On top of that, you're going to have to say that it is a disaster. We don't think it's a disaster of the level. There's kind of a sliding scale. People want to say if there is a disaster and the government can do whatever he wants, and then other people will say, well, it's not a disaster, so we can't do anything. We can be in the middle. We can say, look, there are things that are a disaster, but you still are obligated to have competitive bidding to the extent that you can. So, and you still have to have something. Some part of this, and so lack of competitive bidding we think is an issue. So then we already talked about this, and this is is written to be relatively readable. I try to write these things so they're readable. So then we have this application for temporary injunction. So this is not a TRO situation where we're asking for an immediate temporary restraining order. There's a $300 million contract that's on its way. So we're just going to say, look, we're going to serve this, and we're going to have a hearing, and we're going to say, look, we want the court to stop this, and then we want to litigate it. While some of the allegations may require the trier of fact to examine the merits, trier of fact is who? The jury or the judge. Other allegations are clear. The contract exceeds 2-year limits. Do we care about the 2-year limit? 2 years. So where do we have that? Let's see. Exceeds 2 years. Constitution, Texas Constitution, Article 8, Section 6. Let's go there for just a second. Article 8. Let's go right here. We cheat a little bit. Section 6. Just for 2 years. That's not it. 2 years. Look at that. Withdrawal of money. Section 6. No money shall be drawn from the Treasury but in pursuance specific appropriations made by law, nor shall any appropriation be made for a longer term than 2 years. So you're beyond 2 years, you lose. That by itself should knock this thing out. Anyway, so, and then there's the question of, is it specific? We think that if you've got an appropriation, there's no specific appropriation for this. So that's what we're doing. We want this to be void. I missed back to where we were. And temporary injunction. And then we have some things, mootness and immunity. They're going to say that every government agency says we're immune from everything, and the government pretty much protects itself, so we have to have exceptions to that. So that is the case. There are, we're trying to declare the contract is invalid for statutory invalidation, the authorization, issue a temporary injunction, and we want Texas to stop this. Invalidate, and we also want to invalidate the Disaster Act for its unconstitutional application at the very least. A lot of the suits that you've seen on this that some of my friends have filed try to invalidate the Disaster Act in its completeness. I mean, it's totally unconstitutional. I think it is totally unconstitutional because of a lot of things it does, but we don't have to have that to get there. You can just say it's in this application, the governor's gone too far. And so that's what we're trying to do. And if you download this, you can look at the contract. This is the actual contract. And it's got the whole thing, budget, statement of work, budget, and you can see all the things they're supposed to do. And you see the MTX response way down here. This is their response that got them the gig. Do you have any questions?
I don't see any comments.
No comments, no questions. Good. Okay, I like that. I wanted to kind of give you a bit of a, let's see, where am I? Wanted to kind of get you, we have 2 other suits that are in the works. One is for nursing homes, as you may or may not have heard this week. The nursing home folks have said, we're going to give you some unspecified rules. We're going to work on it, though. We're going to let you meet outside under certain conditions. We don't think it's anywhere near where it should be. So we are accepting plaintiffs for that case. People have asked, are these class actions? No, these are not class actions. I've been burned. I'll just say it like it is. What I find is I'll work for a bunch of people, and I think this should be light. What is the word phrase? Many hands make light work. And a lot of people give a few dollars, and we have enough money to do this. In the case with the smoking case of Arlington a couple of years ago, what I had was 8 bars doing the work of 80 bars, and so I don't do that anymore. I'm working for my clients, and so if you have somebody in a nursing home that you'd like to see that you're being prevented, let us know about that. That's going to include a number of organizations that it's not all old people. Some of it's housing for autistic folks and things like that. So we're doing that. We're also doing one for some bars, and that one should be done in a few days. If you have a bar and you are not being allowed to operate at all, because the governor has suspended the law, which he doesn't have the power to do, then let us know. And what else is there? Something else to look forward to. And you need to let people know about this. In the last cycle of the session, last session of the Texas State Legislature, they lowered the amount that the local establishments, local governments can raise your taxes without getting your permission. In the old days, previous to a couple of years ago, if a city council wanted to raise your taxes by 10% or more than 8%, then they had to have an election by the people to approve that. That was lowered to 2.5% or 3.5%, depending on who you are, in this last session. The governor apparently has said, we're not going to pay attention to that. So a lot of local cities and ISDs are going to go back to the 8%, and they're going to say, the governor has let us do this. And so that's going to be the next big thing, and I'm going to encourage you to fight that and to say, no, you don't get to do that. The governor does not get to unilaterally decide that your city council can raise your taxes by 8% or 10% or 5%. There's a law, and he doesn't get to suspend that. Now, we may find out that the court's going to protect the governor all the way up. We may find that way. These things are all arguable. But as far as I'm concerned, if the Disaster Act does what it says it does, if it says the governor can make and suspend laws that keep him from being able to do his job, then he can suspend all of the laws. It says he has to even re-up this disaster every 30 days. What's to keep him from saying, oh, I can move the voting era and extend early voting? Oh, it turns out he's doing that. Nobody seems to care. At what point do we start saying, you've got to be rational? You've got to start doing things. We can't live like this forever. There are countries all over the world that are opening up their schools. The number of small children that have contracted the virus since we learned how to use it and died is very small. And people do that every year. And we don't shut down schools. And these things are having a price in many ways that you cannot find because nobody cares about that. Dr. Fauci doesn't. If somebody commits suicide, that's not on his radar. He doesn't care about that. He cares about people who die from the disease. So all the people are talking about disease. They're not talking about any of the other destructive things that are happening. So I'd urge you to make people aware of this, and you've got to stand up. People have to stand up and say, no, you are not the king. You have to follow the law. I didn't harp on it this time like I normally do. Article 4, Section 8. Here, let's pull it up. It's right on my banner. Let's pull it up because it's fun. Texas Constitution. You may not be able to see it because I think it's open image new tab. There we go. No, it's not going to work. It's probably closed up. Article 4, Section 8. Let's pull it up this way. This is the actual Constitution, as it is on the online.
Switch displays.
Switch displays. Oh, sorry. Thank you. There we go. The governor may, on extraordinary occasions, convene the legislature at the seat of government or at a different place in the case that there's a possession of the public enemy, like the governor. No, I'm just kidding. Little. Or in the case of the prevalence of disease threat. So the governor has a solution. If he wants really bad to do this stuff, call your legislature. That's what they're for. I don't know how many other constitutions and state constitutions have the word disease in them, but ours does. Our state legislature and our people did this, and it wasn't that long ago. We amended this in 2001, so I'm not sure what was going on there, but the governor has a solution. And this ongoing, I am smart enough and good enough and doggone it, people really like me, so I can make laws. Ex cathedra, the Pope of Texas can't do that. I'm sorry. So anyway, if there are no questions, I'm going to go now. So thanks. I'll probably do this again next Friday. I hope to be able to talk about another case. Thank you and have a good weekend.